and welcome to the ICT Pulse podcast. I'm Michele Marius, your host and the editor and publisher of ICT Pulse, the online platform where we discuss ICT issues from a Caribbean perspective. Today, we will be discussing the European Union's EU's new General Data Protection Regulations, GDPR, and how they might affect Caribbean businesses. These regulations were approved and adopted by the EU Parliament on the 27th of April 2016, and with provision made for a 2-year transition period, they will come into force on the 25th of May 2018. Although most laws tend to govern what happens in their home country, similar to its predecessor, the 1995 Data Protection Directive, the GDPR is different. In a nutshell, the GDPR will not only apply to organizations located within the EU, it will also apply to organizations located outside of the EU if they offer goods or services to or monitor the behavior of individuals who reside within the EU, which is why we believe it is absolutely vital that we who are outside of the EU get a better understanding of how the GDPR might affect us and our businesses. To that end, we are pleased to have Bartlett Morgan, an attorney at law at Lex Caribbean in the Barbados office. An area of focus of his practice is Internet Law and Policy. He's a member of the Internet Law and Policy Foundry and of the International Association of Privacy Professionals, and is quite active in the region's Internet governance community. Bartlett, thank you for coming on the show.
Michele, thank you very much for having me. It's absolutely a pleasure to be here.
Okay, before we jump into the discussions on the GDPR, I just want to emphasize that although the law has been adopted, it has not yet come into effect. As a result, we cannot say with absolute certainty exactly how some of the provisions will be implemented and what will be their true impact. Bartlett, you have anything to add on that?
Yes, you are absolutely correct. As it stands right now, we are still awaiting the actual coming into effect of the law. And so until May 25th, none of us know for sure exactly how some of the provisions, certainly the newer provisions, will be implemented and how they'll be applied in real terms. And so we can't say for certain, but certainly we can make very educated guesses, I think, based on what existed prior. And certainly the signals which have been sent by what are called the DPAs out of Europe, which is the data protection authorities in the different countries in Europe.
Okay, great. Okay, so Bartlett, although our focus is the GDPR, let's perhaps just start by providing some context. Currently still in effect is the Data Protection Directive, which was adopted in 1995 and was implemented in 1998. So it's almost 20 years old now. Can you give us a sense of some of the key principles or mechanisms of the directive?
Okay, so I think how it's important to discuss the directive versus the GDPR is to zone in on the key differences. But before doing that, I think it's just important, broadly, just to speak to data protection in general, which is that you're really trying to put in place a series of mechanisms that will enforce the protection of personal data and the handling of it. So to go back to the question of the Data Protection Directive, one of the key differences, which is different with the directive and the GDPR, you'll notice that one was a directive and one was a regulation. Now, in the context of European Union law, the difference is this. When a directive is given, in large part, it's really high-level objectives that are issued as directives, and it's left up to each individual member state to decide how they'll implement it and what their laws will look like to implement that directive. Whereas with regulation, effectively the regulation itself is the law, and there's no need to further then go and implement it again in each jurisdiction in the European Union. So that was one of the first major changes, and I think that came about, primarily to allow for greater streamlining of the data protection laws between the different member states, because obviously that has a bunch of business benefits there. If the laws are streamlined, then it makes compliance easier for companies doing business across Europe. And if it's easier to do business, then profitability goes up. because, there's greater predictability and so on, which in a way, I think leads me to another major difference, which also I think goes to the core of the GDPR versus the Data Protection Directive. So under the Data Protection Directive, I don't think it was very certain as a feature about the sort of bundle of rights of an individual whose data is being processed and who had the rights in respect of that data. Under the GDPR now, by comparison, it's made patently clear, and I would argue that this is sort of the fundamental underpinning of the GDPR, that personal data belongs to the person to whom that data attaches. So in other words, your personal data is yours, regardless of how it's generated and who holds it. If it's in respect of you, then it's yours. And this may not seem like much, but it's actually something of a paradigm shift. Because if you think of the way, and let's step away from the GDPR and the European Union for a second, and just think everyday reality here in the Caribbean or in the United States, very often businesses see the data that they collect as theirs. They view it as their property because they've gone about collecting it and putting it together. But now the GDPR, as opposed to how it was under the Data Protection Directive, it's now made it patently clear that the data is no longer the person collecting its property, but the property of the person to whom it relates. So those are the two, I think, major differences we're looking at. And there are a bunch of others in terms of the actual features of the new GDPR that were absolutely absent before. One of the key ones that comes to mind is the notion of privacy by design. And this is, you could argue a fairly philosophical concept that goes back to the 90s. But it's been given effect in the GDPR now. And what it really means is that when you're putting together systems and so on, you should ensure that privacy and the protection of privacy is paramount in the design of that system from the get-go. And so your systems are designed from the jump to consider the privacy implications of accessing and processing the data of individuals. And we can go on into more detail, but for now, I think those are the important fundamental differences we're looking at between the Data Protection Directive and the impending GDPR.
Okay, thanks so much for that, Bartlett. One of the points that you made that I just want to touch on is the whole issue of personal data. And probably if we can just get a quick definition for what that constitutes. Because, I think we probably think about it as probably like your details, your address, your telephone number. But,
Yes.
Are there other aspects that,
Yes.
at least under the EU provisions, would be considered personal data of which we should be aware?
So here's the thing that's really novel about the new GDPR. It has imported an expanded definition of personal data. And so what it now means in real terms is that, in effect, any information that can be used to identify you is now considered personal data. Whereas before, under the directive, it was a fairly limited definition of what constituted, your personal data, but now it's very broad. And so even things like your IP address under the GDPR is considered personal data, which is hugely significant because it means that lots of services, even people, offering, and there's a big debate now, which I should segue into just for a second, about whether or not things like cookies and so on in websites can be said to constitute personal data. That's one of the ongoing debates that obviously won't be resolved until the GDPR is fully implemented, because the idea is that a person could use that information to eventually triangulate and figure out who you are. And so by definition, it would constitute personal data. And so I think that's pretty significant that they've taken this very deliberately broad brush approach to defining personal data.
I hadn't been aware of the whole issue of cookies, so that's great because, again, the way how the internet and how online platforms work these days is that they're all about collecting as much data as possible on their subjects, on their customers, on their clients.
Yes.
We now have a situation where there has to be some prudent and responsible management of that sort of data, and the platforms cannot just do as they please with it anymore.
Yes, that's very, very true. You could argue that the sort of freedom of entrepreneurs to just dream up an idea and implement to some degree will be curtailed now, because you'll have to be more conscientious of how your great ideas will impact the people using whatever product or service that you launch. And so I think what it's going to require is certainly more creativity as, startups and so on think about launching new products now. And if not creativity, certainly more mindfulness of how it's going to play out and impact everyday people who use your products and your services.
Oh, that is an excellent point, and something that at least I wanted to raise probably a little bit later on. I at least want us to just focus on sort of setting up the framework for the GDPR and then looking at the application. So I'm going to come back to the whole issue about, small businesses and entrepreneurship and how the GDPR probably will affect them.
Yes.
But let's just continue looking at some of the other provisions. So in my own little preparation for our interview this morning, our discussion this morning, I came across, and I had been hearing about the terms data controllers and data processors. And I just want to get, your help in understanding what the two are, what's the difference between the two, and how, I guess, eventually we as individuals or businesses external to the EU, how those might be reflected or how we might be required to implement them, if at all.
Yes. So I won't deep dive into the technicalities of the GDPR, but suffice to say, the data controller is the person that decides the how and the why of how personal data, of what is going to happen with your personal data. Then the processor, is a person that will, as the name suggests, processes the data. Now, you could, in a sort of theoretical way, you could see the processor as being more or less subsidiary to the data controller. Since the data controller is who, for all intents and purposes, you'll probably be providing your data to, directly or indirectly. But the other thing too, which I think needs to be clarified, is that very often in real terms, you may wear both hats, and you may be both the data controller and the data processor. And I say that to say, certainly persons in the Caribbean have to be mindful of that. So let's say you have a website, you have some great idea for a website, you collect personal data, whatever that data may be, names, addresses, IP addresses, that kind of a thing. And then, you'll have some database somewhere where all that information is stored. And then you can use that database to do whatever, maybe generate reports and, provide insights and that kind of a thing. In that kind of a scenario, you're both the data controller and the data processor. Whereas in a more clearly defined situation where the roles are very different, what you may have is that you may be the controller and you collect the data and so on. And you have or even if you don't collect the data, you decide how the data is collected, but then you then hand it off to another party to process it on your behalf. In that situation, then the roles are different. And we don't even need to be highfalutin about this. Think practically. You're running a small business, and let's say you're using Google Apps to help you to support your business functions. As a small business, you decide what kind of information you need from customers to run your business and to provide services. But then let's say, you don't have all the money to buy some, leading edge, software. And so you use your Google Docs and you have a spreadsheet, Google Sheets. And whenever you get some customer information, you input it into that sheet. Technically speaking, in that context, Google and their cloud service, where that's stored, would be the processor, but you're the controller as the business owner. And so these are very practical ways, I think, of illustrating the difference instead of just, going in and just reciting the text on the GDPR, which, it needs some life added to it.
No, absolutely. Absolutely. And I certainly see it as well. Another example that when I was sort of thinking it through myself is you have a online business or a business and you have payments that you're collecting.
Yes.
And you may be collecting it, let's say, via a platform such as PayPal. You may not necessarily hold like the credit card information and all of that of your customers.
Yes.
PayPal does.
Yes.
Right? And they're processing those transactions on your behalf.
Yes.
But so you are still the controller because you require this data.
Yes.
But, I guess there are certain responsibilities that have been delegated to PayPal. Who is processing your requirements on your behalf.
Yes, very true. Because you are still determining the how and why. Mm-hmm. You determine that the how is that the data will be passed from you to PayPal. And you've clearly determined the why so that payments can be processed. And so you would clearly be the controller in that situation. I think that's a good example as well. And, this actually segues into, I think, another aspect of it, which is, what practical difference does it make which one you are? The practical difference, I would say, without going into too much detail, is another new aspect of the GDPR, which wasn't present before the data directive, which is significant, and I would describe them as prohibitive fines for non-compliance with the rules. And so one of the things that has had many businesses, large and small, running somewhat scared and certainly paying more attention to the GDPR is the nature of the fines, because the fines can be up to 4% of your global turnover as a business. Obviously, if you're operating on a scale where you have a global business, first of all, 4% is fairly significant. I mean, that said, it is capped at, I think, 20 million euros.
Yes.
But the point remains that because there are no actual fines, and depending on which role you have, that may determine what level of fine will be applied to you and the circumstances in which fines will be applied to you as well. So in that sense, I think it's important going forward that if, for whatever reason, you conclude that you fall within the ambit of the GDPR, you need to be clear on, among other things, where you fall. Are you a processor or are you a data controller?
Okay. Now, as you mentioned there about whether or not you fall within the ambit of the GDPR, but the question is, as it is right now, it looks as if anyone who interacts, whether or not you are, how do they say it now? You're offering goods or services or monitoring the behavior of individuals who reside within the EU, you will fall within the GDPR. So are there any circumstances where the GDPR would not apply? Or any classes of entities that would not be subject to the GDPR?
Well, yes, there are a number of ways, I think, of tackling that question. But I think it's important just to pause here for a second to sort of explore something which you just touched on. And what you're really describing there is what they've described as extraterritoriality of the GDPR. And all that is fancy speak for saying that even though this law is made by the European Union, and ostensibly it should, impact persons, living within, the state, it reaches outside of that. And so even though you may be outside of the European Union, depending on your activities and so on, you may be brought within the scope of the act, and, they may enforce against you if you breach the act.
Yes.
So I think that's important to point out. But what I would say is that you are correct, because the GDPR does definitely have an element of extraterritoriality. And what it actually says, which I think is largely important for us, is that the regulation applies to the processing of personal data of subjects who are in the Union, as in the European Union, by a controller or processor not established in the Union.
Mm-hmm.
So, wherever you are.
Yes.
But it does specify to say where the processing activities are related to the offering of goods or services, irrespective of whether there is payment for the goods or services. But it must be offered to persons in the Union. And so I think straight away we sort of do away with the largest, misconception we have, which is that whoever you are, anywhere in the world, once you're doing business, period, that it applies to you. So, but the reality is, if you are offering goods and services, you have intent to offer goods and services to persons within the European Union, then regardless of where you are, and especially in this interconnected digital world that we live in, it means then that you ostensibly fall within the scope. Also, if you engage in any business where you're monitoring the behavior of persons within the European Union, then you fall within the scope as well. And so, based on those two things, we can straight away see things like social media networks. You come up with some social network or the other, or there's Facebook or whatever. Though based on certainly that second part about monitoring the behavior, they would fall within the ambit of the GDPR. I think it's important to point out though that there's a context to everything.
Yes.
And when you read back through the GDPR and you go back through the very extensive recitals that foreshadow the actual provisions, one of the things they make clear is that there's actually going to be a test that will be applied. So even if on the face of it, you have a website, for example, and let's say someone in Europe, they go on your website and they're able, in theory, to buy something from your website, based on the test that has been outlined in the GDPR, that in of itself may not mean that your business will be deemed to fall within the extraterritorial reach of the GDPR. The test that they've outlined is pretty much whether or not it is apparent that the data controller or processor envisaged offering goods or services to data subjects in Europe. So that's a test that will be applied. If it's clear that it is apparent rather, that's the phrase that they actually use, that you clearly thought about offering goods and services to persons in Europe, then they'll consider you to be within the extraterritorial reach. But if it's clear that you never necessarily targeted them, then it won't. And so they'll use certain things to consider. So, for example, let's say you are a Chinese business, for example, and you have a website, but in addition to being in Mandarin or Cantonese, it's also in English and German and French. Now, in a situation like that, then I think a reasonable inference will be drawn that you clearly intended to target persons within the European Union, because those are languages of member states of the European Union. So I think a reasonable inference could be drawn there that your online, product or service that you're selling was targeted at Europeans, and therefore, ostensibly, you fall within the extraterritorial reach of the GDPR. Another example could be where, for example, you see on your website, #1 website for selling Chinese products to Europeans. Clearly, you are sort of self-identifying that you are the kind of person that is offering services to Europeans. You intend to offer services to them. And in those circumstances, they'll definitely say, well, you are within the scope of the GDPR, and therefore, if you breach some aspect of the GDPR, then, potential administrative fines may apply. But however, on the flip side, I should point out, though, that simply having a website that persons in Europe are able to access won't put you within the scope of the GDPR, even if you're selling products and services to whoever may come. So the GDPR doesn't envisage, to my mind, you set up a website called antiguanthings.com, and you're in Antigua, and you're primarily selling products to persons in Antigua, but ostensibly anybody in theory can go onto your website, put in their credit card information, and buy the product. Just by that alone, it wouldn't bring you into the scope of the GDPR by itself.
Okay. And I guess thinking just probably a little bit more broadly, because I think for many of us, especially Caribbean businesses that may be have goods or services that we want to provide on the global market.
Yes.
So again, it is that, you have your website or, whatever platform you decide to use.
Yes.
And you are offering your goods and services. But if European residents seek to buy it, then again, would you fall within the ambit of the GDPR, or just because you're now just supposedly serving a global market of which the EU residents are a part? Well, what happens?
Well, I think it's going to come down to certain sort of common sense indicators more than anything else. And again, so in a broad sense, if you happen to have a website and it just so happens that persons in Europe can't buy from you, I don't think you will. In my mind, on the face of it, I don't think that in and of itself would constitute you being somebody who has envisaged, targeting Europeans. If persons from Peru, Guyana, wherever in the world can log on and buy the same services just like anybody else, then I don't think an inference could be drawn that you are targeting Europeans. However, if, for example, your website, if I'm in Europe and I try to go to your website and it resolves to a European top-level domain, for example,
yes,
or based on where I go to your website from in the world, it uses geolocation and then it redirects me to a specific version of that website. And so let's say I'm in Europe and I go to your website and it redirects me to the European version of the website. I think in those cases, even though you're selling things globally, I think a reasonable inference could be drawn in those kind of situations that you do intend to target Europeans, and therefore you would fall within the scope.
No, absolutely. Certainly, if you are seen to be targeting, the European market, then clearly.
Yes, that's the real, I think, underpinning that certainly SMEs, well, all businesses, to be honest, operating from our region need to be mindful of. Mm-hmm. So there's no need to sort of run to the hills just yet. The Europeans aren't coming, so to speak. I really think it's just a case of being mindful of the kind of business you're operating in. The reality is the internet is no longer a Wild West.
Definitely.
And increasingly you're seeing regulations coming in from different countries and so on, which are sort of forcing us to adjust how we behave on the internet nowadays and how we do business on the internet. And I think the GDPR is certainly a clear leading example of that.
Question: are there any sectors in particular or industries or segments that you think probably need to pay particular attention to the GDPR and its application?
Yes, I definitely think so. Just thinking it through, one of the biggest examples that comes to mind potentially is the BPO sector, the business process outsourcing sector. I think that's one of the clearest examples of a sector where, depending on where you're getting business from, you may want to be mindful of the GDPR. and it may potentially impact you if it is you're doing business processing for entities that are in Europe or established or have some arm in Europe and so on. You're processing that data coming of Europeans, for example. I think in those kind of circumstances, your operations may fall within the ambit of the GDPR, and you may want to look at it some further, and we can talk about it some more. I also think just the international business sector also needs to be mindful. Depending on where you live in the Caribbean, the international business sector is either a big part of your country's economy or it's non-existent. So certainly in locations like, I can think off the top of my head, Barbados or St. Lucia, where this is a significant source of income for the government. How it works is, in a nutshell, you set up a company in the country, but the company doesn't offer services or goods locally in the domestic market. It's purely set up to offer services and goods and what have you to persons outside of the country. And they primarily do that because of the tax benefits and so on. So if you have some international business setup that's a part of a group, and that group of company operates in Europe, and some of the processing, of the information and analysis happens in the offshore location, in St. Lucia, for example, then I think ostensibly you also fall within the GDPR. There has been some sort of debate here in the region about whether and the degree to which it impacts tourism interest. My initial assessment is that it won't impact them heavily, save and except for their web properties and their web offerings. So if, for example, and it goes back to the discussion we're having just now about, whether or not it's apparent that you're targeting Europeans. If on your website, I can go on your website and book your services and pay for them or what have you, and your website, is targeted to me in Europe, as many of the larger hotel chains in the Caribbean do. So if you were to go on the website for some of these large hotel chains from Europe, you'd realize that it resolves to, .ie or .fr or .uk, for example. And so clearly, I think that, as well as the copy on the website, makes it clear that they are targeting Europeans. And so to the extent that Europeans can interact with those websites and in that interaction personal data is passed, yes. But in terms of your actual bread and butter offering of somebody flying to, Grenada to stay in a hotel, I don't think that in and of itself would bring you within the scope of the GDPR. Certainly outside of that, though, certainly I think a lot of these startups in the Caribbean need to be mindful of who their markets are. So, you have some web-based software, some cloud-based app or what have you. You need to be mindful of who your market is for your product going forward. And then obviously work to suit. I think also on that same line, the e-commerce websites as well, I think those persons need to be mindful of what it is they're doing from the region. And then I think also email marketers. The last time I went through the GDPR, one of the things I noticed was that they make specific mention of of these directed campaigns, which is really, depending on how you look at it, a lot of this email marketing and stuff. So I think those are examples of sectors that we see examples of in the region who may potentially want to consider their operations. And you could argue as well, those retail outlets, those large retail chains that may have operations in any European country or what have you, they may also want to consider the degree to which they fall within the ambit of the GDPR and then take the appropriate next steps.
Okay. That is an, I guess, non-exhaustive list so far.
Yes.
Because as you were talking, I wondered about international financial services, since that is also big in the region.
Yes.
You have any thoughts about that sector in terms of whether or not their business might be affected by the GDPR?
In my mind, I would sort of lump international financial services within international business.
Okay.
And the considerations I think are largely the same. Is your international financial sector set up, whatever entity or you have, that facilitates that, is it targeted at persons in Europe, in a European country? If the answer is yes, then you may want to consider the degree to which you fall within the ambit of the GDPR and the steps you may want to take.
Definitely. I just also want to just touch on the BPO, because I guess as much as BPO meaning business process outsourcing, we also need to also consider and include within that what I consider the shared services space. So when businesses large corporations pool their certain functions in certain locations, or you bring work offshore out of, like in developed countries, to the Caribbean.
Yes.
So although it appears to be happening internally,
yes,
that it could fall within the ambit of the GDPR, especially if, for example, I'm thinking just off the top of my head, banks, whereby you may send the work offshore, let's say to the Caribbean, processing transactions that have happened during the day.
Yes.
for whatever
Yes.
reason, and it's being done within the region, then you may find that I would think that there potentially might be some scope within the GDPR.
Yes.
Granted that if you're such a large organization, you're probably definitely serving European customers anyway.
Yes. So I think where you ended is I think the starting point for the response, which is I mean, I hate to say this as a lawyer, but it's true. It depends. I mean, it depends on where your customers are. So to use the example of the banking, even though I think it applies generally, regardless of the business you're doing, it's a general sort of consideration. Where are your customers that you're processing the data on behalf of? Are these persons in Europe? Then if the answer is yes, then you definitely have to be mindful of how that impacts what you do, because in effect, when you start sending those services, shared services off to locations in the Caribbean, to kind of do your back office processing, as it were, then effectively those locations in the region become processors within the meaning of the GDPR. And so those locations themselves have to be mindful of their specific obligations under the Act and so on.
But question though, because I'm now thinking as when I was doing my research, would the companies, let's say for in the looking at the back office situation, would the companies be able to send that work to the region? Because aren't there not provisions about the fact that the legislative frameworks of the countries to which work is being sent or data is being sent should be comparable? The data protection the data protection provisions should be comparable to what obtains in the EU.
Yes, so you've hit a really big nail on the head there, which I think ties into a larger conversation that we need to be having in the Caribbean about what exactly it is we're doing in terms of our development focus and the impact of legislation on that. So in the context of the GDPR, there's allowances in there for sort of trans-border data flows. So there are circumstances within which data of Europeans can be, sent to other countries for purposes including like processing. So to use the example of the BPO sector. But one of the challenges is, in real terms, you are not allowed as a data controller or processor within the European Union to send that data out to a location that basically hasn't been certified by the EU as being, fit for that purpose. And so essentially, this is a practice which continues. It's here under the current Data Protection Directive, and it's going to continue under the GDPR, which is where essentially different countries are assessed, and then they are basically given, a rating as to whether or not their overall framework, legislative framework, and so on within their country is sufficient to allow data from Europe to be sent to those countries. As it stands now, I think perhaps under the current regime, there are maybe 12 countries in the world that have received that designation. So that includes, I think, countries off the top of my head like Argentina, Liechtenstein, a bunch of countries that are close to Europe as well. Funny enough, the United States of America and Canada have only been given sort of partial certification in that regard. And the idea being that their laws, including their data protection laws, are not sufficient to guarantee full protection to the data of Europeans were it to be transferred to those countries. And I think that raises a conversation that we need to have in the Caribbean, because the reality is it's in our interest to know, given the size of the European market, to ensure that at the very least we have laws in place that would ensure that we can get the kind of ranking that we need to sort of open up, if it's not already opened up, a market, certainly in the BPO sector, for getting this kind of work. Because if you look at the state of the Caribbean now, certainly in the larger, more developed jurisdictions in the Caribbean, we don't really have any data protection laws substantively. I think off the top of my head, in Jamaica, there's been constant debate over the past few months about passing one, but as at the time of this conversation, there's no Data Protection Act as yet.
Yes.
Trinidad has partially passed one, but the really substantive provisions that would actually give teeth to it haven't been passed as yet. Barbados has been discussing ones for maybe upwards of a decade now, but it hasn't been passed as yet. And so the question then becomes, what are we doing in the Caribbean? I mean, are we really going to allow this potential opportunity to pass by not passing the relevant legislation that would at least allow us to open those doors and have these services, more BPO services, coming into the Caribbean?
No, definitely. And it's certainly not limited to BPO. There may be a lot of businesses and services that just bypass the region because we don't have the data provisions in place. So I'm even just thinking generally, we have had initiatives over the last maybe 5 to 10 years where whereby more data centers are being established. And
Yes.
we probably at this point cannot really market those data centers in Europe because we don't have the provisions in place to legitimately say that we can store and manage the data, protect the data to the standards that the EU requires.
Yes. So that's certainly, I think, a significant consideration. And it goes to all kinds of potential business ventures, online IT services. You could think of remote access services, cloud-based services. I think until we get to the point where we actually start passing the relevant legislation, and even though it's not just legislation, it's a part of what they consider in terms of their adequacy considerations.
Mm-hmm.
But certainly it's a big part of the puzzle that we have to get right.
Yeah. Okay, I think though we've been it for a little while now, and I feel as if I've been holding you hostage. So
No.
And I think as I'm beginning to get a sense though that certainly this is not a conversation that we can just wrap up in one session. We probably need to take some time, see how the GDPR starts to take effect, and perhaps continue the conversation, maybe at some point deep dive on a particular issue when it really has raised its head as something that probably requires further discussion, and just generally perhaps wait and see how things start to shape up once the GDPR comes into effect. So I think that we should probably just start to wrap this session up. Let us probably try and salvage, the rest of our days. And I think though, just to probably close this session, which I promise will be one of many, I think, and hopefully, Bartlett, you will be available to join us in subsequent discussions.
Certainly, I'd love to.
Okay, so great. Let's just think through now. What would you think would be, maybe 3 to 5 things you'd advise Caribbean businesses or even businesses outside of the EU? What can they do to better position themselves for the GDPR?
So, I think the first thing I'd say is don't panic. I don't think the GDPR requires anybody to panic and, run around with a hair on fire. What you should do, though, is spend the time to sort of assess your business and consider what your current practices are. Consider the gaps, what the gaps are, and how you can potentially fill those gaps, just in terms of good privacy practice. Because here is a larger reality I think we need to consider in the Caribbean, this wider field. Data privacy is going nowhere. It's going to be with us for the foreseeable future. And so the GDPR is, at the very least, a sort of de facto good practice, where if you voluntarily sort of bring your organization within compliance, you really are sort of, ensuring that you future-proof your organization in terms of compliance going forward. And especially in a context where, even though many states in the Caribbean have not as yet, passed data protection laws, it's clear that they are about to. The momentum is there. Trinidad is halfway there. Jamaica is about to pass theirs. The discussions in Barbados have restarted again about actually publishing an updated Data Protection Act. In other jurisdictions, they've already been passed, I think in St. Lucia, for example. And so it means that's where the world is going anyway. So it may be in your interest, just as a function of good practice, to start spend some time, have a look at the GDPR in a broad sense, just for the sake of having good practices in place anyway. Beyond that, I would say if it is you've done an initial assessment and you are of the view that your business falls within the scope of the GDPR, then start doing very basic things, and it kind of goes in line with what I discussed already. But certainly, you want to have ensure you have a data breach strategy in place. What if in fact the private data is impacted somehow? What do you do then? You need to have those considerations in mind. You need to ensure that if it is you believe that you fall within the remit of the GDPR, that key staff members are trained in just good data and privacy practices and principles, basic things like that. And I would say perhaps most importantly is that privacy is more than necessarily just ticking some boxes. It's really a mindset. And so good privacy practice is about a certain mindset and a certain culture in your organization. So regardless of whether or not there are acts that say you have to do it or statutes or what have you, I think it's important just to take on the particular mindset and start considering things like privacy by design, where from the jump, when you think of your next great idea that's going to change the world and make it the next Bill Gates, from the jump, once you start planning that idea and start putting legs on it, ensure that privacy is one of the key considerations, because that's the world that we live in nowadays. Privacy is a significant consideration nowadays.
That is so true. The whole issue of privacy, and I just to underscore what you're saying, Bartlett, the whole issue of just your privacy policy. Some of us who have had businesses, you may just sort of throw up a privacy policy that you pick out from somewhere, and you yourself are not familiar with it. It is not sort of imbued into your organization, and I think just little things like that, being more mindful about the privacy practice the privacy policy that you have put in place, and what systems are then needed to ensure that it is effective.
Yes.
And that it can withstand scrutiny.
Yes, certainly. And I don't mean to sort of provide the conversation, but if it is, in fact, you do fall within the remit of the GDPR, you will have to prove, or you may be called upon to prove that you have sufficient systems in place, and those systems will be scrutinized to ensure that the principles outlined in the GDPR are being upheld by you in your business.
This has been such a enlightening but also sobering discussion. As much as you say not to panic, it has been such an interesting topic, and one that I just feel as if we definitely need to come back to it over and over again. As you said, privacy is not going away, and I think that oftentimes in the region we feel as if we can just fly under the radar for a number of things, but as with the internet, we are all on display. We are all exposed. We are all subject to scrutiny, and certainly our businesses as well. So we really need to become more responsible. As you said, the internet and that whole platform is no longer the wild, wild west. Structures and strictures are being put in place.
Yes, certainly. So I think the mindset has to change.
No, definitely. Okay, Bartlett, I think I'm releasing you right now.
It was a pleasure. It was an absolute pleasure.
Thank you so much for joining us, and we hope that you'll definitely be available. We hope that you'll be most definitely available for another episode when we again deep dive into the GDPR as well as privacy issues.
Certainly. I look forward to it.
Okay, thanks again.
All right, bye-bye.
That's it for today's episode. Thank you so much for listening to the ICT Pulse podcast. You can find links to some of the things we talked about on our website, ict-pulse.com. If you like this episode, please show your support by leaving us a review on iTunes, as it will help others find the show. You can email us at info@ict-pulse.com or drop us a note on our Facebook page, facebook.com/ICTPulse, or via Twitter @ICTPulse. We hope you'll join us again for our next episode. Take care.